from Deputy Desi Ellis to the Minister for Jobs, Enterprise and Innovation, the occupation of the Paris Bakery, Moore Street, Dublin 1 by staff.
First off, I'd like to welcome the workers and union representatives who are in the gallery here today. Minister, the Paris Bakery on Moore Street closed its doors. This kind of thing is always a sad occasion. People are left out of work, wondering where the next paycheck will come, or how they will pay the next bill, or even put bread on the table. But for the workers of the Paris bakeries, these concerns have been at the forefront of their minds for over 3 months. That is how long employees of Ruth Saville and Yannick Forrell have been without wages. That is how long they have been working for free in the hope that in the end things would be made right and they would receive their remuneration. When the owners of Paris Bakery decided to lock the doors and lock their workers out, it became all too apparent to these mostly young migrant workers that they had a fight on their hands. Staff are owed over $55,000 in unpaid wages, free work that the owners profited from. It is said that the owners also owe about $200,000 in unpaid taxes and how much in PRSI payment as well. One owner also has a stud farm, which is a type of business which already pays a tiny level of tax. Some staff have already been made homeless due to the refusal of the owners to pay wages. Others, having lost everything, were forced to borrow money to leave the country. They are now outside of the country and in debt due to the bad practice of the owners of the Paris Bakery. The workers who remained decided drastic action was needed and so began to occupy the premises of the Paris Bakery to protest and highlight their mistreatment. It is bad enough that we demean and mistreat those who cannot find work. Bad enough we exploit young people with job bridge scams. But the state cannot allow workers in employment to be mistreated so severely. The very fundamental of an economy is that a fair day's work deserves a fair day's wage. That is exactly what these workers are being denied, having given their labour in good faith. What the owners of the Paris Bakery have done should be a criminal offence, and they should be liable to be arrested and charged for such a crime. I know that Minister Burton met with the workers last night, and I welcome that. I ask that the government do all that it can to offer help and support to these workers and to bring a resolution to the problem. The state has a responsibility to intervene in such cases of abuse and unjust behaviour by employers and business owners. Owed wages should be paid and workers compensated for the hardship they've had to endure over recent weeks and months. It is not good enough to go off, set up another business and leave a trail of misery and deprivation behind. We need to ensure that people get what's owed to them, whether it's redundancy, wages, holiday pay and other benefits. We call ourselves a modern society, but we have antiquated laws and we need proper workers' rights, ones that this government promised. When will this happen? We need action and solutions, not ministerial visits with no follow-up. I call on employers to do the right thing. I also call on you, Minister, to intervene in this case because of the hardships that have been endured by these workers.
Thank you, Deputy Minister.
First of all, I'd like to thank Deputy Ellis for raising this matter. I think I absolutely share his concern. This is a really worrying situation that has evolved here. Clearly, I hope that the concerns of the employees can be resolved to their satisfaction quickly and they can end the sit-in that has occurred. As you know, the NERA has met with representatives of the employees last Friday and informed them of their rights of entitlements and means of address. They've also provided continuing contact details, and I understand they are seeking to they're in active contact with not just the employees but also the employer in order to try to resolve the situation. You raised the issue of workers' rights. Ireland has a very significant body of employment rights enshrined in legislation, and included among these is the Payment of Wages Act of 1999, which contains protection for employees and provides a means for redress for employees who have not received their full wages from their employer. Non-payment of wages or any deficiency in the amount of wages properly payable by an employer to an employee on any occasion will be regarded as an unlawful deduction from wages unless the deficiency or non-payment is attributable to an error of computation. The Payment of Wages Act 1991 provides a right of complaint to a Rights Commissioner for any employee who has not received his or her wages or who has had an unlawful deduction made from wages. A complaint must be presented to a Rights Commissioner using the prescribed form within 6 months of the deduction or non-payment of wages that give rise to the complaint. It should be noted that a number of employee rights at this point, I understand that no such application has been made. It should be noted that a number of other employee rights come into play as a result of the closure of a business, including minimum notice and redundancy. Under minimum notice and terms of employment acts, an employee who has a minimum of 13 weeks service with an employer is entitled to notice of termination of employment. The length of notice to which an employee is entitled is dependent on the length of service of the employee and can range between 1 week's notice for an individual with less than 2 years' service up to 8 weeks' notice for an individual with more than 15 years' service. Where an employer is unable to provide or does not provide the appropriate notice, then the employer may make a payment in lieu of the notice. An employee who does not receive their minimum notice entitlements may take a case to the Employment Appeals Tribunal. Under the Protection of Employment Act 1977, companies proposing collective redundancies, that is where at least 20 people are employed, must enter into consultations with employee representatives at least 30 days before anyone receives notice of redundancy. They must also notify the Minister for Jobs, Enterprise and Innovation of the proposed redundancies at least 30 days before any employee receives redundancy notice. The consultation with the employee representatives and notification period for the Minister can run concurrently. I understand again at this point no application for redundancy or no notice of redundancy has been served by the employer. In accordance with the Redundancy Payments Act, employees who have at least 2 years continuous service with an employer are generally entitled to a statutory redundancy payment in the event of being made redundant. The administration of the redundancy payment legislation is within the remit of my colleague, the Minister for Social Protection, who has advised that it is the responsibility of the employer to pay statutory redundancy to all eligible employees. However, where an employer can prove to the satisfaction of the department that he or she is unable to pay statutory redundancy to his or her employees, that Department of Social Protection will make lump sum payments directly to those employees. Such payments are made from the Social Insurance Fund and result in a debt being raised against the employer, which the Department of Social Protection will seek to recover. Where an employer either fails to comply with his or her redundancy payment obligations or where there is a dispute regarding redundancy entitlements, claims may be referred by the employee to the Employment Appeals Tribunal. Where an employer is legally insolvent and as a result defaults on payment of wages, an employee may also be entitled to seek redress from the state under the Insolvency Payment Scheme. These payments also cover overtime, holiday pay, sick pay, etc. In these circumstances, redundancy payment entitlements may also be made from the Social Insurance Fund. I have been informed by the Minister for Social Protection that she has received no formal notification from the company. A company may be put into liquidation by its members. An alternative is that the company's creditors may apply to the courts to have the company put into liquidation. Employees owed wages or other payments count as creditors and would be entitled to apply to have the company put into liquidation. If the employees and the employer agree that conciliation or another form of intervention might assist in resolving some of the difficulties they are facing, the State's industrial relations machinery is available to assist in this dispute if required. Even what often appears to be the most intractable of disputes are capable of resolution where both sides engage constructively in good faith in this voluntary process. The principle of good faith implies that both sides in a dispute make every effort to reach an agreement and endeavour through genuine and constructive negotiations to resolve their differences. Ireland's system of industrial relations is essentially voluntary in nature, and responsibility for the resolution of industrial disputes between employers and workers, whether in redundancy or other collective disputes, rests with the employer, the workers and their representative. But the state provides industrial relations disputes settlement to support parties in their efforts to resolve their differences. All of the agencies and bodies under the remit of my department remain available to the parties if they can be of assistance.
Thank you. Deputy Ellis, 2 minutes. Thank you.
I thank the Minister for his reply. It seems very clear that this employer has not engaged, not just with the employees, but with the departments. And it's very clear from what you said. I think it's outrageous that workers should be treated like this. Many of them now have even left the country. People haven't got bread on the table. They can't pay their rents. They're living literally like homeless people. It is an absolute scandal that it should happen in this day and age. I think there is an onus now for the Minister to take a far greater hands-on approach and to push these employers. This is not the first time we've seen this. We've seen this on a good number of occasions, and these are the worst kind of examples we've seen with the workers in this case and the way they've been treated. And I really do think that it's high time that the Minister puts down and tells these employers what to do, how to that they have to live up to this. And it seems very strange that this company is supposed to be moving to another premises. So they have money to go off and set up a new business elsewhere, and at the same time the employees are punished as a result. I think it's scandalous, and I think we need intervention and we need pressure put on these companies. We don't have proper workers' rights. It's very clear from the way that these employers have handled this case that we are behind in terms of workers' rights, and we need to strengthen that, and we need to really put it up to these employers. They cannot be allowed to treat people like this. It doesn't matter who they are, they should not be allowed to do it. Thank you.
Thank you. Minister.
The Deputy has raised a number of points. I mean, this is certainly a very disturbing situation, but I can't comment on the veracity of some of the things the Deputy has said. Obviously, if there is a situation of serious unpaid taxes, that's an issue for the Revenue Commissioners. And as you know, they have powers in respect of any company which fails or has unpaid taxes. They have very, very extensive powers, including the power to put such a company into liquidation. NERA, who are the enforcement agency on behalf of the department, they are engaging with the workers and with both sides. They certainly have certain powers. There are, as I outlined in my reply, there are ways in which the justifiable unpaid wages can be pursued through the Rights Commissioner Service, or in certain cases, as I said, through the Employment Appeals Tribunal. So there is that route which to date hasn't been activated. It's at a situation that none of the, if you like, the triggers have yet been activated that can be pursued in this case. I know, obviously, the employees as a creditor have the power to initiate an action to seek to get the company to wind up. But there is, I recognise that there is a difficulty in relation to the payment where a company doesn't actively declare insolvency. Under the present legislation, it's only in the event that the company either approaches the department or is insolvent can the insolvency fund be triggered. Now, that is an issue I understand is being examined by the Department of Social Protection as to whether changes need to be made in that area. But in this situation, we're still, NERA is engaging with both sides. None of the, if you like, mechanisms have yet been activated, either redundancy mechanism, the Rights Commissioner mechanism. So we are at a point where, the services of my department will continue to be available in whatever department, either through NERA or, if necessary, through the Labour Relations Commission, to assist in this case. So I hope that we can come to a solution, and I know that the agencies are very actively engaged with this. And if you want to add additional material from, clearly you've made statements there, which are clearly material, particularly in relation to the revenue commissioners, if they in such a matter.
Thank you. That completes